My name is Avery LeBlanc, and for my 14th Amendment project, I chose the case Obergefell versus Hodges, same-sex marriage. Same-sex marriage has been a debated topic for decades, but the landmark case Obergefell versus Hodges made a significant amount of progress for our country. Background: James Obergefell and John Arthur were in a loving relationship for 22 years. John was diagnosed with amyotrophic lateral sclerosis, ALS, in 2011, and he became terminally ill. They were living in Ohio, where the state bans same-sex marriage, so they flew to Maryland, where they could legally wed. When John passed away, Ohio refused to list James as John's surviving spouse on his death certificate, preventing him from receiving the benefits. James Obergefell felt that it was unfair that he had cared for his lover all those years, but he can't be seen as having any legal connection to him. Obergefell versus Hodges is a consolidation of 6 lower court cases from Ohio, Michigan, Kentucky, and Tennessee. Obergefell, along with 13 others affected by the ban on same-sex marriage, sued the state officials and argued that the statutes violated the Equal Protection Clause, the Due Process Clause of the 14th Amendment, as well as the Civil Rights Act. The violation of the Equal Protection Clause was that the government cannot pass laws with the idea to discriminate against a certain group of people and prohibits one's ability to have life, liberty, or property. By the government not allowing same-sex couples to legally wed, they are being discriminated against, even though they are still American citizens. The questions debated and challenged in court were as followed. Does the 14th Amendment require a state to license a marriage between 2 people of the same sex? And does the 14th Amendment require a state to recognize a marriage between 2 people of the same sex that was legally licensed and performed in another state? Leading up to the Supreme Court, the district courts ruled in their favor and agreed with the couples. The respondents appealed the decision to the United States Court of Appeals for the Sixth Court, holding that the Constitution does not require a state to recognize same-sex marriage from other states. The Supreme Court granted a consolidated petition for the review of the case. Trials. The trials began on April 28, 2015. The plaintiffs were represented by civil rights lawyer Mary Bonato and Doug Hallward Driver, a Washington, D.C. lawyer. On June 26th, a historic day for equality, the court decided that the Dual Process Clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects. They declared that the analysis applies to same-sex couples as it does to opposite-sex couples. The court answered that marriage should not only be defined between a man and a woman just because it is the only bonding that can produce a child. The court held that the marriage right should be recognized across the states. Supreme Court ruling. Justice Anthony Kennedy, a judge with an overriding concern for liberty, delivered the majority opinion that was 5-4. The majority held that the state's same-sex marriage bans are a violation of the 14th Amendment due process and equal protection clauses. Justice Anthony Kennedy's majority opinion was joined by Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, seen in the picture on the right in the rainbow-colored gowns. Justice Anthony Kennedy saw the history of marriage not as a concept permanently defined, but instead free of interpretation, which had the potential to change. Kennedy cited 4 principles and traditions behind the constitutional protection of the right to marry. First, the right to choose whether and whom to marry is inherent in individual autonomy. The right protects the intimate relationship between 2 people. Third, the right protects children and families by giving legal protection to home building and child rearing. Fourth, marriage is the keystone of the social order and the foundation of the family unit. The benefits were as followed: tax benefits, inheritance rules, evidentiary privileges, and medical decision-making authority. DOMA. In 1996, Congress passed the Defense of Marriage Act. Section 2 says that Congress believes that other states should have the ability to ignore marriages of the same sex entered into their state from another and choose to not treat them as legally wed. Section 3 says that the federal government does not have to acknowledge and honor these marriages. DOMA addresses the consequences of these particular marriages for purpose of other states or federal laws. In support of legal same-sex marriage, Justice Kennedy saw that DOMA influenced a stigma and saw how DOMA violates the Constitution. The lead dissenting opinion was written by Chief Justice John G. Roberts, Jr., and 3 others joined along with him. Chief Justice Roberts believed that the majority ruling should not be a legal decision and that states should be free to say what is considered marriage, seeing the Constitution does not define it. Under democracy, he did not see the value in their concern with the case and could not understand how the people could celebrate under the Constitution when he is not proud of how the decision was made. In his word, "But this court is not a legislature. Whether same-sex marriage is a good idea should be of no concern to us. Under the Constitution, judges have the power to say what the law is, not what it should be." Another thing that he said was, "If I were a legislator, I would certainly consider that view as a matter of social policy, but as a judge, I find the majority's position indefensible as a matter of constitutional law." Justice Alito argued that the Constitution produces a flawed definition of marriage and that the decision should not be in the hands of the courts. He also believed that the decision was a threat to religious freedom and feared that future opinions against this ruling would be punished and unable to freely speak. In his words, "I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes, but if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools." Justice Thomas noted the consequences of distorting the doctrine of due process. The doctrine doesn't have the right to create new substantive rights. He believed that there is not freedom from government benefits and that the party is not being deprived of life, liberty, or poverty. In his words, "The majority claims these state laws deprive petitioners of liberty, but the concept of liberty it conjures up bears no resemblance to any plausible meaning of that word as it is used in the due process clauses." Justice Scalia found the majority decision a threat to American democracy and accused them of legislating, not judging, as in his mind the question was not based on law. He did not believe that as a member of the Supreme Court he had the power to make an ethical decision to do right by his government. In his words, "We have no basis for striking down a practice that is not expressly prohibited by the 14th Amendment's text, and that bears the endorsement of a long tradition of open, widespread, and unchallenged use dating back to the amendment's ratification." Conclusion. In light of the decline in marriage over the past decade, Obergefell served to reinvigorate and strengthen a waning institution of marriage. Dating back to 1970, there was a debate and fight for gay rights. Beginning in the year 2000, states began to legalize gay marriage, but it wasn't until this case, in 2015, that the ruling would ban restrictions to same-sex marriage across the United States. Same-sex marriage increased significantly in the states that previously banned it. These marriages were now truly finalized as legal protection would be given to those married under court rulings. Celebrations and rallies full of tears and cheers took place across the country. It was a celebration for a landmark ruling that will go down in history as a turning point for the country. A win for the LGBT community. Same-sex couples felt a level of freedom, now able to be together anywhere in their country. Around 293,000 same-sex couples have wed since the Obergefell case, which created an economic burst. That number has doubled since then. Traditional views were finally changed, and as a fundamental right, marriage was finally extended to same-sex couples. Impact. The result of the Obergefell v. Hodges case proves to have a major impact on people's lives today. Same-sex couples have the ability to marry in all 50 states and can be seen as equals. Economically and emotionally, there has been a positive difference, and the decision has not changed since. While some states may challenge the acceptance of same-sex marriage, the Supreme Court requires all states to honor the legalization of same-sex marriage. Before this trial, the institution of marriage was an unfair, biased system, limited to only couples of the opposite sex. Thank you.